absolutely.
For you to come to a just decision to say whether Section 83 has been complied or not.
Yes.
But you are also saying this court needs to stay so pertinently to give guidance to say if KZN is a bit uncertain, Gauteng is a bit uncertain, but Kunuk didn't say on these facts this should be prospect of success, even if not mentioned in Section 18 specifically.
Thank you. Thank you so much, Justice. But,
I just wanted to so that I've been like.
no, thank you. Well, yeah, thank you. You brought me back where I wanted to be. I was just responded.
Yes, but I also want to take you to what you were quoting on paragraph 30 of Bila.
Right.
Because you left there as one sentence that says this is despite the fact that the issue of prospect of success is not specifically mentioned in section
Absolutely.
itself.
Thank you. That's with the greatest respect, Justice Mata. That's I only deviated because the President asked me to leave that point. So thank you for bringing that. Actually, to be honest, I mean Justice Machumi. Sorry, Justice. This case, to be honest, Justice Machumi, is about what you have raised, and that is it. Because if unless somebody can show us that Bila and Justice Alliance and Ntlameza and UFS and GNOB are all wrong on this, then you cannot succeed in the SCA or on any appeal without having established prospects of success, without even pleading them. Forget about establishing. You can't. Why? Because and as Justice Machuma, as you put it correctly, the court in Bila says that this is a fourth element, even though it is not mentioned in Section 18.3. But it goes to, let me do this. Two fallacies about this, and I'm glad to have an opportunity so that my learned friends can address this. Most people think that the judgment in Ntlameza and AfriForum, because in those cases, both courts said, because the record is not in front of us, we're not going to deal with prospects of success. That is always, always have to tell this to students. That's a mistake of not being able to distinguish between 18.3 application and an 18.4 appeal. In an 18.4 appeal, it is theoretically possible to deal with that appeal without determining the issue of prospects of success. Why? Because the court will not have the record, as it didn't have the record in Ntlameza, as it did not have the record in UFS. But in a Section 18.3 application, it is impossible not to have to deal with prospects. You can't do it. You can't just pick and choose which requirements you're going to determine. So it's fatal, and that's the word that is used in Bila. The omission to deal with that is fatal to the entire appeal. Or rather, it's fatal to the case, so the appeal must succeed on that basis.
Are you elevating the requirement of reasonable prospects of success as a statutory requirement?
No.
But it's not mentioned in section.
Yes, that's exactly what the Justice has said. The court said in Bila, although it is not mentioned in 18.3, it is a requirement of the law. And let me explain why that is so, Justice Salduka. Remember, I kept on saying you must, the word remain, you must emphasize. The fallacy is this. The question really is this. Did the introduction of Section 18.3 do away with the common law requirements? That's the real legal question. As Justice Sutherland found in that case. Because Justice Sutherland said, yes, now that we have Section 18.3, prospects of success, in other words, the introduction of 18.3 has now done away with that requirement. right? Then came the Justice Alliance judgment, which said, no, that's wrong. That element, the element of prospects of success, which was in the common law, remains. In other words, but absolutely, that's it. That's the end of the case. If you, as I say, Justice Alduga, as you know, that's why I made the example of murder. If you don't plead one of the elements or prove them, how can you win? I don't understand. If we accept that this is a requirement, one. Number two, we also accept what is said in Bila for obvious reasons, that the onus, not only is it a requirement, but the onus is on the other side. It must be, because it's part of the higher onus. How do you discharge an onus which you don't deal with in your papers? It's impossible. We all know the law has been repeated many times that you must make your case in your founding affidavit. Just like you can't put one of the requirements of interdict, just sneak them in the reply. You have to plead it in the founding affidavit. So it's fatal. Now, of no. Mm-hmm.
Because my understanding of that judgment is that if the exceptional circumstances have not been established, you don't get to.
That is true.
Meaning, if we are with you,
on
that those were not established, we don't have to deal with.
Absolutely. No, that's exactly. That's 100% correct, Justice. You remember when I talked about the so-called three legs? I said that the so-called third leg will only arise if I'm wrong on the exceptional circumstances, irreparable harm, and all that. You're 100% right. No, put it beyond doubt that effectively this is how it works. The court starts, as you correctly put Justice President. The court will look. Forget about the points in limine and what have you. The court would look at the statutory requirements that are not controversial. And if it finds that there's no exceptionality, or there is irreparable harm to Mr. Zuma, for example, then that's the end of it. It has no discretion to exercise. Remember, the element of prospects of success arises in the form of a discretion. So it has no discretion to exercise, so you're quite right.
So if the statutory requirements have not been met, we don't get to discretion.
Yes, but I've made...
We don't get to prospects of success.
Yes, except for in the following context, which is what Justice Alduga was raising. Except if you look at it through the lens of what I call a point in limine. In other words, is the non-pleading and the non-establishment of one of the four elements, you'll work with me, when I say four elements, I know that's disputed, but for now, assume that I'm correct. Is the non-pleading of any one of the four elements fatal? The answer has to be yes. Then that's the end of it. Then you don't even have to, if you look at it, so you can do it either way. You can either look at it from that point of view and say, the non-bleeding of one of the four elements is fatal, goodbye, as was done in Bila. Or you could take the approach that is being suggested. It's a longer approach. I would say I wouldn't recommend it myself. But then you would have to go to exceptional circumstances, irreparable harm, and then after that you say, oh, by the way, there's also no bleeding of the prospects of success. That wouldn't be the most prudent way to do it, but it can be done both ways. With the greatest respect, we would commend the approach suggested, implied, I don't want to put words in the Justice's mouth, but implied in the question from Justice Buchumi, which is that the starting point, there are two starting points. Is it a requirement? Yes. If it is, on who does the onus lie? And did that onus-bearing party discharge the onus? Yes or no? That's it. And,
so before the extraordinary relief contained in Section 18 can be granted, you have to stand.
Absolutely. And Justice Saltuka, that's actually those words that you've just said are almost a mirror image of what Justice Binsward said. And this is another point that gets missed, that this is not just about prospects of success in the air. It's part of the exceptionality of this remedy, and that's a crucial point. If the court can allow me just one indulgence to explain this properly. One has to go, everyone just talks about Justice Alliance, but nobody actually looks at it. In Justice Alliance, at paragraph 27, which has been affirmed 100 times in this, well, I'm exaggerating, but in every case that has come before this court, 100%, I think it will be better. Yeah. It has been affirmed 100% in this court. It says at paragraph 27. And you'll remember, incubator is the Sutherland J case. This is what Justice said, and I'm going to read this because it's so important. It says, differing in this respect from the approach propended in incubator holdings, I consider, in other words, differing from this thing that says prospects are no longer important, I consider consistently with the view expressed by Corbett J.A., very important, in South Cape Corporation at 545E, that the court's assessment of the prospects of success in the appeal, factor 3, underline that, factor 3. I'll explain what factor 3 means. Factor 3 in South Cape Corporation remains a relevant factor in the consideration. Indeed, counsel on both sides in the current matter were in agreement with that proposition. I hope the history will repeat itself. It follows that the less sanguine or confident a court seized of an application in terms of Section 18.3 is about the prospects of the judgment at first instance being upheld on appeal, the less inclined it will be to grant exceptional remedy, the point that Justice Salduka has just made. The less inclined it will be to grant the exceptional remedy of execution of that judgment pending the appeal. Now here, it says, the same quite obviously applies in respect of a court dealing with an appeal against an order granted in terms of Section 18.3. And this is where the confusion always lies. When the court says this, it means that, this is obviously with the benefit of hindsight. You can add there that in certain situations, this is now about the appeal court, where the record is available. That's what this court has just declared. That as far as the appeal is concerned, if the record is not available, you can still go ahead. But here's the most important part. It says, the position is very much akin to that which pertains when interim interdictory relief pending the judicial review is being considered. There's the giveaway. The position is very much akin to that which pertains when an interim interdictory relief pending a judicial review is considered. In other words, there is an onus, as is with the interdictory relief, and that onus is on the party that seeks the relief. But let's see what factor 3 is being affirmed here, because everyone just talks about prospects of success glibly. But if you go to, you can use that in, you use the same judgment of Justice Alliance, where it quotes South Cape. This is factor 3. You remember before, these were the 4 factors that we all grew up on. 1, the potentiality of irreparable harm or prejudice. 2, I'm cutting some words. 2, the potentiality of irreparable harm or prejudice being sustained by the respondent. And 3, this is factor 3. Let me read it out slowly so that it can be dealt with, hopefully, by my learned friends. Say, the prospects of success on appeal, including, more particularly, the question as to whether the appeal is frivolous or vexatious or has been noted not with the bona fide intention of seeking to reverse the judgment, but for some indirect purpose, e.g. to gain a time or to harass the other party. In other words, factor 3, which was being affirmed, you have to prove 2 things if you are the onus-bearing party. 1, you must show that there are good or bad prospects of success, but also show that the appeal itself now, what Justice Bonan correctly calls the main appeal, you must then say that appeal, you have a burden to show that appeal is mala fide. In other words, Mr. Zuma is not really aggrieved by all those things listed in the application for leave to appeal. He's just playing with the court. Where in these papers do they even attempt to do that?
Is it not sufficient that the appeal lacks reasonable prospects of success? And is it not relevant for the present debate that in fact, as far as the main judgment is concerned, an application for leave to appeal has already been dismissed?
No. Yes, okay, thanks. One of my juniors asked that question. No, it's not. And the reason is very simple. Just as, if you remember, we were wrongly accused in the judgment, by the way, of having objected to the application, or to the Section 18 application being lodged before the application for leave to appeal. We didn't do such thing. It would be ridiculous to do that. All we said was that because you have not seen the application for leave to appeal, it does not lie in your mouth to say that it has no prospects of success. Because you don't know. What if, as it happened, there were 12 points, I just counted them this morning, 12 points that are raised there. So that's the answer to that. So in the same way, Justice Ponan, again is the judicial intervention. Remember, at face value, it might look that way. That how could you even bring a Section 18 application when there's no application for leave to appeal? But the court have said, no, you can do that. Because if you can anticipate that there is indeed an appeal coming, then you are free to do that. In the same breath, here, if you look at paragraph 16.3 of my learned friend Mr. Badlander's heads of argument, he says that it is anticipated that there'll be an appeal. Otherwise, we would be wasting your time here. And as we said earlier, Justice Ponan. And that appeal obviously will come in due course when the 30 days or whatever the period is. But it has already been indicated and is accepted by everyone else. So it goes back to what you raised earlier, Justice Ponan, which is that the fate of that petition, actually, that's what it will be. The fate of the petition lies elsewhere. It will be dealt with by 2 judges in the normal way. It might go to the Constitutional Court. Nobody knows. And that's, by the way, is one of the reasons why in KNUOP, the discussion of this issue of prospects of success, Wallace J.A. goes as far as to say, remember that even when there are no prospects of success, the appeal may still succeed. Because as we all know, the appeal may succeed on the basis of Section 17, 1A, Roman 2, which is that there are exceptional circumstances, not exceptional circumstances, there are other grounds upon which the appeal should be held. So that's why Justice Wallace says that even if, when you look at it, you may say, these prospects are weak. Remember that prospects of success on their own are not the only gatekeeping mechanism. So the answer is the dismissal of that application for leave to appeal has no bearing whatsoever. And rightfully, my learned friends have not raised that point because it would be quite frivolous. Yeah.
But I do have a question.
Thank you.
You submitted that in relation to Mr. Downer, there was no allusion whatsoever to process of success.
Yes.
That was not pleaded in relation to Mr. Downer.
It's mentioned somewhere.
What is the criticism in relation to how she has dealt with it? Because there is reference.
Yes. But yes, thank you, Justice. Justice President, surely, if a court is examining whether, let's say, you have passed the threshold for establishing irreparable harm. It can't say, you mentioned it in your affidavit, and therefore you have discharged the owners. You must discharge the actual owners. So mentioning it in the context of saying, remember, Justice, that in any event, even if they had actually done more than mentioning it, it would have been a shot in the dark. Because they did not, unless if they are sangomas of some sort, then they would have said, okay, we know what your application for leave to appeal is going to say. We know that even if you're going to raise 100 grounds, all of them are going to be frivolous. Not only that, according to so-called Factor 3, those grounds will also be malafide. How? So, if you like, the discharge of that onus, mere mentioning and moving the lips and saying prospects of success on appeal, cannot amount to discharging an onus. And nochal, the heavy onus that we're dealing with here, which is a superlative, a higher onus than normal. So, and it is in that context, Justice Miller, and I really have to emphasize this point. Let me add to that. Now, you can say, okay, we forgive you for not dealing in substance with the prospects of success in the founding papers. That should not be forgiven, but let's be kind. You say we forgive you for that because, why do we forgive you? Because at that stage, you had not seen the application for leave to appeal. Right. What do? In the answering affidavit to Ms. Bourne, we then attach the application for leave to appeal, which is an invitation now to say, okay, maybe we'll overlook the fact that you might want to deal with it in reply. But here it is, here are the grounds. In reply, which you will find at page 490, she doesn't take the invitation. Nowhere, even in reply, do they say, okay, we had this handicap in chief, where we did not deal with prospects of success. But now that handicap has been cured, and we now have an application for leave to appeal. But it's nonsense. Nothing. They don't even do that. We would be debating a different thing now about whether you can do that in reply and so on. They don't do it. So how on earth could anybody, any court, find that they've discharged the heavy onus on prospects of success? It's impossible, Justice Muluma. It really isn't. You can't discharge an onus. This thing called an onus means literally a burden. It's a burden on your shoulders which you must overcome.
It's to me that in respect of prospects of success, she has also taken into account and relies on the finding of the court that there was an abuse of prospects.
Yes, but that's a non-argument with respect. That's what I was. You can't say you lost because you've lost. You can't say no. So you can, but you shouldn't. In other words, what do I mean by that? What I mean by that is that Justice Mulumela, Madam Justice President, if we all understand that the purpose of Section 18 is effectively to protect the losing party from the judgment which is adverse to it. It's already adverse. So you can't make it more adverse by saying, okay, in now doing the Section 18, we're going to look at the adverse judgment. Then no losing party will ever win a Section 18 application. Because every time we'll say, no, but look at the judgment, you lost. You can't. This court and that court had a duty in terms of Ines ACJ, as it then was, to scrutinize the abuse allegation and see if it holds any water. If it holds water, as I say, then we must lose. If it doesn't hold water, as I've amply demonstrated based on the three myths upon which it is premised, then you can't. You can't. That's why we call it in our heads lifting. That court was lifting itself by its own bootstraps, because what it is saying is that because we found abuse against you, then we're going to use that finding to now find against you in the 18.3. It does not work. It can't work like that, because if it did, no one would ever succeed. No. Oh, sorry, Justice. If you maybe finish. Okay. Yes. Yeah. yes. Sorry, I'm sorry. I didn't mean to interrupt. This is the thing, Justice. This is a deeply philosophical issue, and I'm afraid I'm sorry to sound like a broken record. You have to start as your starting point from the fact: why do we have Section 18 in the first place? It is there because it wants to, and in honesty, at least to give credit where it's due. I think it's my learned friend, Mr. Badlander, whether in his heads or in the affidavit, I'll deal with it in reply. But they say that when they put the so-called harm, they say if the judgment is suspended, then it will take away the operationality and the executability, and they say, which means the effect of the judgment. And they are right. We agree. Because the purpose of Section 18 is to take away the effect of the judgment and suspend. Suspend in the Oxford Dictionary means that to put the force and effect of something in abeyance. So you can then go and fetch it from that dustbin of abeyance and say, I'm now going to use the very same judgment. That's why I was saying when I answered this question earlier, there's the reason for Section 18.4. Because Section 18.4 is meant to protect us from this very question. Because every time we come here, we would be told, no, but look at this. But 18.4 says, no, that is suspended. Apart from the fact that it was already suspended in 18.1, right? So that's why I'm saying the court cannot lift itself by its own bootstraps. Because why? Because the whole purpose of this thing is that one day this court or the Constitutional Court may find that there's no abuse of process. That's the whole purpose of why we're here. We're here to protect that idea, to protect the idea that one day a court will find that there's no abuse of process. So if we want to subvert the entire exercise of Section 18, then we must do what is being suggested and say, no, let's work on the basis that the appeal will be overturned both on here. Imagine, in fact, let's look at it in terms of the real law. Imagine the irreparable harm that would be caused to Mr. Zuma if not even this court, ultimately the Constitutional Court says there was no abuse of court. That's what Section 18 is there for. Because then he would have gone through all this trauma, all these adverse impacts. For what? For something that's non-existent. For something that the Constitutional Court or this court will find was spurious based on false premises, as I've demonstrated. Imagine that. That's what Section 18 is supposed to be. You can't imagine the other way. Because if you're saying, I'm going to imagine that the abuse will be upheld, then you are favoring the winning party, which is, I don't even know what to call it. It's a catastrophe. Section 18 was meant to exactly stop that. You can't favor the winning party in the assessment of these questions. You have to favor the losing party because I'm sorry. Yes. Okay. Okay. Yes.
May I kindly request you to wrap up in 5 minutes?
Yes.
Thank
you very much. Just okay. Sorry. Yes, I can say the 5 minutes. Right. Okay. So let's wrap it up like this. As I've said, It doesn't matter which way you look at it. You can start with the 3 requirements, or you can start with the prospects of success. Our humble submission is that this court should take the approach that was taken in Bila. And the retort by the other side, where it says, but Bila was decided before KNOB, is like saying nothing. Because it doesn't matter whether Bila was decided before KNOB. It would only matter if KNOB departed from the position taken by this court in Tlameza and Free State. And nobody, I don't think in their right mind, will say that KNOB did any such thing. So the position in KNOB, in Tlameza, in UFS, and in Bila is consistent with this idea of retaining the common law element. Think about it like this, Justices. There are 2 types of legislative intervention that can be made. The legislature might say, here's the common law position. We don't like it. It's bad. It's oppressive. It's not consistent with our constitution. And we are changing it. Holus bolus. Or the legislature might say, as it did here, here's the common law position. We like it, but we don't think it's sufficient. We want to add on to it. That's what justice... so the word remain means that. So Section 18 could not have done away with the requirement of prospects of success, which was already there, because the court was not breaking, it was building on top. So that base, it remains there. Prospects of success is there, and then you add all these other 7 things. Number 1. Number 2, the onus has to be on the onus-bearing party for the reasons explained by Justice Salduka, which is that this whole debate is part of the exceptional remedy in the first place. So it's adding yet another hurdle, if you like, for the winning party. So it's impossible. I'll go as far as that, and that's my last submission. It's impossible for these parties to. It was impossible to have succeeded in the court of law, and it's impossible for that same reason that they can succeed here. And this appeal should be approached in the same way as the Bila approach, because the Bila approach is correct. It's based on the judgments of this court. It's based on the Preferable Justice Alliance approach, and it is commendable. And if you just give me 1 minute, Justice, so that I can refer to the reason why I attached to this document the latest judgment, which is a judgment of Mushwana. That's the UNET, RAF versus UNET. It's Mushwana J, Malungana AJ, and Skosana AJ. I just want, I don't have time now to build it, but I would recommend. This judgment is probably one of the best expositions of why we have Section 18, because it starts, as I said earlier, with the issue of Ines CJ, and it uses words like unseat. It says if you want to unseat the default position, then you must do this. You must do this. If you want to unsettle, so in other words, the starting point must always be when somebody puts an application for leave to appeal or intends to appeal, that judgment is suspended. Unless there are exceptional circumstances, there's irreparable harm, what have you. So the starting point is, you must read Section 18.1, starting from the words, from the default position. If someone is intending to appeal, they must be protected by the suspension of that judgment. Full stop. But of course, as everything in law, there are all exceptional circumstances which might make you to deviate. The question here is, has anything been said here to deviate from the default position? The answer is no, on the 3 statutory requirements alone. And the answer is now a big no, if you also consider that the 4th requirement has not even been pleaded. As the court please.